Hi, I'm David Cantor with the law offices of David Michael Cantor. Today's topic is going to be criminal damage, both the felony charge and the misdemeanor charge. In Arizona, the definition of criminal damage is if a person recklessly defaces, damages, or tampers with property, substantially impairing its function or value, then they are guilty of criminal damage. Now, it has to be done either intentionally or recklessly as you're doing this. Now, the punishment, if this occurs at a church, a school, a cemetery, or a mortuary, then it's what's called aggravated criminal damage, and that's a felony. It's very serious. If it's $10,000 of damage or higher, a person can get probation with 0 days in jail up to a year in jail, or prison of 1 to 3.75 years. If the damage is $1,500 or higher, then it's probation, 0 days in jail up to a year in jail, or prison of 6 months to 2.5 years. And if the value is $1,000 or higher, then it's probation of 0 days in jail to a year in jail, or prison of 4 months to 2 years in prison. Now, if the damage was not done at a church, school, cemetery, or mortuary, then it's not aggravated criminal damage, and it's regular criminal damage, which is still a felony depending on the amount. If the damage is $10,000 or higher, probation, 0 days in jail up to a year in jail, or prison of 1 to 3.75 years. If it's $2,000 of damage or higher, again, probation, 0 days in jail up to a year in jail, or prison of 6 months to 2.5 years. And if the damage is $1,000 or higher, then it's probation with 0 days in jail up to a year in jail, or prison of 4 months to 2 years. Now, if the damage is less than $1,000, that's misdemeanor criminal damage, and that can be probation, 0 days in jail up to 6 months in jail. Now, what are the defenses? Well, the biggest defense is not criminally reckless. That means it was just an accident. Everything is not criminal damage. People have car accidents all the time. To show this, we have to show there was no gross deviation from the standard of conduct that a reasonable person would observe in that situation. You could have just simply have dropped a vase. You could have backed into an expensive painting. This doesn't mean it qualifies as criminal damage. You have to recklessly do it, such as tossing a vase in the air while you're in the middle of Tiffany's. That's probably going to be criminal damage if you miss it and it hits the ground. Another defense, lack of proof. Lack of proof that it was reckless, lack of proof on the value. Some people say, well, my beat up 12-year-old car was worth $20,000 when in reality it wasn't. And the fact that somebody's car got keyed doesn't mean the whole car needs to be painted. It can be touched up. So there's a lot of different defenses to this. We've had defense by doing misdemeanor compromises. Agreeing with the other person, settling with them civilly. They sign a document called a misdemeanor compromise and a covenant not to sue, and we can get the misdemeanor dismissed. Many times we can get the prosecutor to agree to drop the felony. Now, if this situation applies to you, a family member, or a loved one, either give us a call or go to our website at dmcantor.com, contact us, and we'll set you for a free initial consultation, and we'll see what we can do for you.